Thank you, David. And I see that this is Dave Nolan over in Ho Chi Minh City. He's the ID chief. Hey, Dave. I just wanted to welcome him first. We're waiting for you to join us. Like David said, this is a panel on fraud, and we're very fortunate to have 4 representatives from this subject. I'm just going to
the day after she's born will be fun.
Bios are available. They can distribute it on. They said it's on the Google Drive.
Probably. We're getting a lot of weight.
For this panel. But I'll just say Martin Long, he's the NID chief in Manila. We've got Russell Brown, he's the CG, the Consul General in Manila. We've got Bob Setchin, he's the Consul Chief here in Hong Kong. And Diane Butler, she's a fellow island member. So I'll turn it over to you guys. If should we start with Dave, since he's on TV? Dave, you want to let us know a little bit about your post and fraud?
Sure. Can you hear me okay?
Hold on, Dave, we don't hear you. We got audio. We got no audio.
That's what I was afraid of.
Let's work out the tech real quick. And he's count to 100. Backwards. Yeah, go ahead and just keep talking.
You're hearing something.
Keep talking. Don't stop talking, Dave.
All right.
1, 2, 3, 4, 5, 6.
I'm not muted on my end.
There we go.
No, it's all right. We're getting it. It's sounding better. Keep talking.
Okay. All right. So, as Wayne said, I'm the immigrant visa unit chief here in Ho Chi Minh City. We believe we handle the 5th largest volume of visas among consular posts worldwide, and we think we're 2nd highest in Ks right now. I've been here about 9 months. Got a staff of 37 Vietnamese and usually about 8 Americans. And
is your post considered high fraud? Is there a lot of fraud cases pushing post?
yes.
If we could bump this level up just a bit, we'll go to Mark.
Yes.
Russ.
Yeah. So my name is Mark Lowe. I'm the ID chief. We are supposed to do about 250,000 visas.
Can we do a quick level check on these mics? Because we're recording this as well. We want to make sure we got good sound. Can you do a check real quick?
You want me to just keep talking? Like Dave, you want me to count backwards? 99, 98, 97.
Are you getting signal? Don't you hear it?
Fraud. I will let the Consul General speak to that, but of course we have fraud. We're on fraud post. We have it on all of our visa categories. I'll stop there.
Yeah, I mean, hi. Manila is, of course, considered a very high fraud post, and we have staffing in accordance with those numbers. We have one of the largest anti-fraud units in the world. And we are, for immigrant visa purposes, we're usually counted as number 3 in total number of cases, not necessarily total number of issuances, but we're definitely number 3 in total number of cases. And we are number 1, just ahead of Ho Chi Minh there, in number of Ks, K visas. We are, I think, probably bigger than all probably other posts combined in terms of Ks, at almost 9,000 Ks per year. Same-sex Ks are about 1,000 a year, something like that. So very, very significant. And then, as Martin said, on NID at about 250,000, that doesn't put us in the top 10 at all, probably about 15, something like that. But as far as American Citizen Services, that's another very, very large aspect of fraud that probably you guys aren't always thinking of, but it's definitely something that you're constantly doing. So it's a big high fraud post. Yes.
Good morning, everyone. Hong Kong is a little bit different. We handle about 100,000 NIV cases a year, but only 1,800 ID cases on average. We have a pretty thriving American Citizen Services practice, which doesn't affect most of you, about 10,000. consular reports birth abroad every, I'm sorry, 10,000 passports, more than 1,000 consular reports birth abroad every year. What is perhaps significant for you is that Hong Kong is a low fraud post. In fact, I'm wondering whether my participation in this panel is fraudulent. It occurs to me that the first time, right?
No, it's just misrepresentation.
Shots. But in any case, we're somewhat we're sort of the outliers here, and we will try to contribute where I can. At one time, I spent 4 years in his office. The legal net folks were all familiar with this, so perhaps I can contribute.
Okay, so let's just go ahead and launch into it. We're going to be focusing on 9 FAM 302.9-4.
Diane, can I just give one more point? Okay. Ron, we need the timekeeper up here. Who's the timekeeper? Okay, we're going to need you up here. And then also, if you have questions, non-case specific questions, we're going to take them as written just because there's a lot of material in this panel, so we'll have 5 minutes at the end. So if you have a question, non-case related, go ahead and write it down. You're going to bring it up to Diane, and then she'll choose from that. What's that, Jared?
I can take the question.
Well, we're just going to take them written. If you want to take the questions and bring them up to Diane, so give them to Jared, and then he'll do.
Speak closer to the mic.
Can you hear me fine now?
Can you speak very close?
I'm speaking really close. Can't get a break. Rodney Dangerfield. So go ahead, Diane.
Okay, speaking of which, we're also focusing on INA 212A 6C1. So if you hear us discuss 6C, that's what we're talking about related to fraud and misrepresentation. And we don't want to discuss these issues in a vacuum, and we're going to focus on 3 different types of activities. Activities related to work, study, and love. And in terms of work, we're going to distinguish between what are considered to be petition-based adjudications. For example, somebody who's already got an H-1B petition approved, L1, O1, as opposed to non-petition-based, which is generally the B1 or B2 application. So, first of all, would you each please comment on whether you view fraud differently from misrepresentation, or it doesn't matter fraud, if you material misrepresentation, you're just inadmissible? Martin, do you want to start with that?
Sure. Yeah, we do view them differently because the FAM says that they're different. And before I say anything more, I should say something more important than any of this, which is what I say here today are my own views. They're not the U.S. government views. I'm not here representing or speaking on behalf of the U.S. government, and anything I say has nothing to do with U.S. government policy. Okay, so these are my own thoughts, and they can't be construed in any way to bind the U.S. government. All of that out of the way. We
Those problems, yes.
We of course view them differently. Fraud has a willfulness and intention to fool someone, whereas the misrepresentation is simply that you are telling something that's factually untrue. That's really the way we look at it. So from our perspective, they're different. Do we treat them differently? In the end, that's a fact-specific situation that I can't really talk about without having facts in front of me. But yes, we treat them differently, and they are different.
Okay, so there was a change to the FAM in March of this year, the end of March. And one of the changes focuses on whether or not the person would be permissible based on the true facts. So, you know, as attorneys, we always think our poor clients were just misunderstood, or you were just so busy you didn't have time to ask them the right questions. one example would be someone who says, who is asked, what are you going to do in the United States? I'm going to work. When what they really mean is they're coming on what we would call business. We know work is a four-letter word. That's what I say that they're coming to work. If they're not coming to, if they don't have petition-based approval. So if a client has been denied, this would be a B1 situation, and because they have told us, they denied me after I said I was coming to work, and they wouldn't let me give any more information. We may want to contact you to facilitate their submission of their application. How would you view that situation, Martin?
She's the one long show. Well, okay, so generically speaking, reapplications are the way to handle a denial or a refusal. We are going to be refusing them, presumably for one or two reasons. Either they're not credible, or they are attempting to do something outside the bounds of the visa classification. So, taking, broadly speaking, your idea of work versus business, we're going to be asking them questions about what they're going to be doing, and if they can't acquit themselves well, that, remember, for your clients, from our perspective, for your clients' interests, the interview is the most important thing. They need to be credible. They need to tell us a story that fits with what the visa class is and what they really intend to do. And if they have gone and told us something that just does not seem to ring true with respect to their application, then they've lost the credibility. We're not even going to get to misrepresentation in that case. We're going to just simply say they're not a credible person. If they have lied to us in the past, then that's a different story. I'm assuming, though, that they will have had an ineligibility put against them, a 6C, to use the section that we're talking about. Those are difficult ineligibilities to overcome, and the applicant has to do their best, which is to be credible, which is to provide us with a reasonable and fully truthful set of answers to questions. They can't be economical with the truth, either thinking they're going to make a misstatement again, or their employer has counseled, well, don't talk about X. That's the wrong way to go about it. The best way is to be forthcoming and to respond fully to the questions we ask. If I ask you, why are you going to the United States? The answer shouldn't be meetings. The answer should be, I'm going to meet with my colleagues and we're going to be discussing sales in the fourth quarter. Something that is actually responsive to the question that's asked. This is not the time. You have a very limited amount of time as an applicant, and you need to be convincing the officer from the very first that you are a trustworthy, reliable visa candidate or applicant. So that's where I'll stop.
All right, and in terms of discovering what the true facts are, we have seen very recently proposals that the DS-160 and DS-260 may begin to require all of the social media handles that a person has used in the last 5 years. Are you currently looking into social media to discover what the true facts are? Let's start with David. David, are you there?
Yes, I am.
Okay, David, we'll see with IB issues.
Right. To be honest, I don't think we've really noticed any change so far in the way we're able to look at social media information or the information that we're been able to get from it. Normally, we have kind of a lower tech approach. When we do a fraud investigation, we'll physically go to the beneficiary's residence and say, "Show us your phone." So the changes to the application forms haven't, and I don't expect will really affect what we'll be able to do in terms of developing information.
Okay, so you already are looking into social media to some extent.
That's right.
All right, any other comments from others on that topic?
Sure, I can speak to this a little bit. So the proposal, there's a proposed rule that has made it out into the press and that kind of thing about adding this information to the DS-160, the DS-260, things that would provide more background on someone, those kinds of things. This is all done with reference to keeping our borders safe, knowing who we're dealing with when they come to apply for a benefit from the United States government. Please keep that in mind. In terms of the how we do it, in terms of what we will do, these kinds of things, that hasn't really been worked out yet. We do use some social media to in the course of fraud investigations to look at finding out whether or not the person that we're dealing with is exactly who they say they are and exactly what they're saying in publicly available fora. Okay, so there are lots and lots of folks out there who will brag about their success in fooling the consular officer on their social media that is publicly available. And yes, we will look at that, and yes, we will apply that to a determination about whether or not the visa should have been issued in that case or not. That is true. So we in fact are already using what's publicly available, just like we would use anything that's publicly available.
Right, okay, there is one other provision under this section, which is the post-files exception, which says that if the truth of the fact is readily available through consular systems or files, it cannot be said that the alien's misrepresentation tended to cut off a line of inquiry. So can you confirm, Russell, can you confirm
Sure.
that prior DS-160 was for this exception?
Look, anything that is readily available to us in our consular consolidated database, so any information that we have on an encounter with that person, with that applicant, or anybody associated with them on their application, including phone numbers, including all of the information that they have submitted, that is considered post files. That is readily available to us.
Great, thanks.
Okay, so I'll take over this part. We're going to cover timely retraction, and kind of segue into alien filing. That is 6E. So I'm going to start off with the warnings. Warnings required before an applicant faulted for felony timely retract, and understanding that there has been some revisions in the FAM over the last 2 years. And if there is a warning, is there a mandatory warning? What type of be, or what type are you using? I'll start with you, Mark.
Are warnings required? No, they're not required. If we think, when we are interviewing someone, if we think that they are telling us a fish tale, then we're going to say something along the lines of, why don't we take a moment here and stop? I'm asking you a fairly simple question. What I need from you is an honest, truthful answer. And it sounds to me, from what you're saying, that we're getting away from that. So why don't we think about it? Why don't you take a moment and think about that? But that's going to presume that I know, or the officer knows, that something isn't right, where something is close. The distinction between being a bank teller and being an assistant branch manager. I'm never going to know that. I doubt that it's going to matter very much, but there's lots of times when things are said that I simply won't know until the day after the fact. So the timely retraction will have long passed because I will have already asked questions. So if the short answer is, if we know something sounds a little bit wrong, we may caution someone about their responses seem to be somewhat incredible. But if we don't know about it, we don't just sort off every interview. It's sort of very unfriendly to say, now listen, don't lie to us. You told us 10 times you're going to tell the truth. This is your last chance. It's not a way to start off a productive interview. It just puts people on edge.
Russell, do you have anything on that?
I will say that there are posts in extremely high fraud parts of the world, like West Africa and that kind of thing, that go ahead and post all of that language in the waiting room. It's right there. If you lie to the consular officer, this will have consequences, et cetera, et cetera. We don't find that just to echo what Martin said, we don't find that in our situation, in our context, that's necessary. I think, though, that there is, certainly in the environment that we operate in the Philippines, we've been doing this a long time. And Manila has been one of the biggest NIV posts in the world for a very long time, and one of the biggest IV posts. And the understanding and sophistication in terms of the applicants and those who represent them and that kind of thing, you know, these go back now generations in terms of family ties and family reunification and these kinds of things. And I think that there is an understanding that if I lie about who I am, if I commit willful misrepresentation, that somebody's going to catch me at some point. However, that does not stop anybody from trying.
Yeah, well, there's a chart that we put in on the Google Drive that tracks the changes to timely retraction in the FAM for I don't know, at least 20 years it was, where you had an absolute duty to warn of the consequences. I think it's at the outset. Yes. And I know that from my own experience, even in Cambodia, that wasn't done. Matter of course. And then it evolves. Interestingly, if you track it on the chart to you must be warned, but it's once you're aware, and then it went to should be warned at the onset of the interview. Now it's back to should warn and confront. That would be no, again, not posting. Some posts we thought that they have a warning post that that just says tell the truth. But that's not, the consequences are important. It's not in the FAM anymore, but they have an attorney general decision that's also online where they say because it's so dramatic, the consequences are so absolute, potentially for IVs for sure, and even for NIVs that you're permanently barred, that was the idea of giving one. But obviously each post is different in terms of how that actually works. How would you look at, with that in mind, how would you look at either old fraud findings that were made in the past or weren't made, and that now they're going to timely retract today for something they said in an earlier interview or wrote on an earlier application, 10 years ago when the old FAM was in effect, when there was that future one. And I'll ask each of you, can answer. Let me ask David first. Yeah. Dave?
Sure. So I don't want to evade the question necessarily, but I want to say that this almost never comes up for us in an immigrant visa context. We are dealing mostly with relationship fraud here, and we don't really get to make the 6C finding ourselves. That goes back to USCIS. So by the time, you can argue, I suppose, if you want to timely retract from them, but for the most part, that's not a call that we're making. And then I'll say, just from my NIV experience, in my experience, 6C really only comes up if you've already decided that the alien is otherwise qualified for the visa. So in most instances, if the issue comes down to one of credibility, you don't believe that the applicant intends to abide by the terms of the visa. That's kind of a looking forward sort of perspective, and a lot of people would just move that to 214B. If you're talking about a previous misrepresentation, at least on the immigrant visa side, most cases the hit would have been entered by USCIS, and you don't have a discussion about retraction or not. You just say, here's the waiver process, and move it in that direction. So that's kind of a long-winded way of saying that this isn't an issue that we spend a lot of mental energy on.
If there was a hit by post, your post had previously say on an NIV and you got an IV,
right,
then you would have the ability to re-examine that. The attorney could bring it up, and then how would that work?
Sure. I mean, we always got the authority to look at posts at hits that we've entered ourselves. I've seen quite a number of hits that I've looked at and determined that they were entered incorrectly. They didn't have, if they needed concurrence, they didn't get it. And we call it clocking out. We can clock those hits out. If we determine in an immigrant visa context, a lot of times what we'll get is misrepresentation on a previous petition. We'll look at the basis for that, and if it's a hit that only our post is entered, we can make an evaluation and decide whether it should stay in or whether we can take it out. If it's a USCIS entered hit, let's just say it's a more complex process that we don't have complete control over ourselves.
Okay, so I'll turn this over to the other folks on our panel. If I could just add this component that where somebody may have to get a B visa, said they were married to somebody, and now later they're coming to get a visa, and they weren't really married to that person when they did it. That probably comes up a fair amount of times. How would you look at that in light of what David's doing?
So what all this comes down to, of course, is what we had just talked about in the last discussion, which is materiality, right? So it's in the context of the individual case. So does the misrepresentation have direct and objective significance to the proper resolution of the alien's application for a visa? So an example would be, I think this is similar to what you just said, Wayne. Like a beneficiary attempted to hide a prior marriage. This is, of course, something that we deal with a lot in the Philippines because this is a country that doesn't have divorce. There's only 2 countries left in the world that don't have divorce. That's Philippines and the Vatican. So there's all kinds of interesting workarounds that are specific to Philippines case processing, one of which is fake death certificates. So the convenient death of a prior spouse in order to take advantage of current immigration benefit, whatever it is. And for a long time there, Philippines was renowned for having large-scale disasters such as ferry sinkings, where hundreds would be killed, all at the same time, and there's no registration, right, for who's on the ferry or whatever. So it was very convenient to say that, my spouse was killed in that unfortunate ferry sinking, and that kind of thing. Now, they will, of course, reappear years later. That's a miracle. But anyway, so an example would be, let's say an applicant submits a fraudulently issued genuine document. And that's something that we also, in our context, I would imagine in Vietnam, that is also the situation where there is lack of control over the genuine documents. Okay, so the document itself is genuine, but the person it was issued to was done fraudulently, something like that. So there isn't an easy answer to that because it depends on the circumstances of the case. For instance, if you have if you have an NID fraud finding, right, but then that is coming to you now as an ID, and it's the same relationship, they just were covering up the relationship with that person for the purposes of a non-immigrant visa, but it was caught. They're now presenting an ID with that same person, and it's a genuine relationship, right? That is a
proves the
big
point.
Yeah, you never know, right? So it's hard to say this is absolutely like this all the time. This is like this all the time because it's not. It really depends on the what is material to that particular case at that particular time.
Let me just quickly move into, thank you for that, the alien smuggling component. Alien smuggling is when you assist somebody or influence somebody for them to do the fraud, right? So we'll call them third party. The 6E, the alien smuggling comes back on this other person to do. If there was no ultimate fraud finding on that third party, 6C, could you still find the alien smuggling, the 6E, on that individual that encouraged, induced, without a specific background?
Okay, so if
something else I want to say.
Oh, okay. All right, so if I understand your generic hypo, if there has been no, or there is not a proper 6C finding, then the 6E isn't going to, I'm sure that there's some way I could construct a fact pattern where it could happen. But in the main, a 6E won't attach because in order to be 6E, it has to be, they have to have done something, and we're talking about either saying something, orally writing something. I'm not talking about being the boat driver for the Golden Venture, or the Golden Dawn, whatever that ship was, it went up on the shores of Rhode Island. We're talking about what you say, so it has to be something material, and if it's not enough to get to 6C, then it's not going to be material for 6E purposes, which requires the same underlying basis, finding untruth and materiality.
Can I throw this in? So if the person, I know we're right at the end of the second, if the person kindly retract, the third person kindly retracted. So there was, in essence, something they were doing that was material. Did you find a 6C on the other, on the person who's first?
So the 6E person lied about something
No,
material.
the 6C person is not 6C because they kindly retracted. Oh, I'm not really married to them. Say it was relevant. It was material. I'm not really married to them. You get the 6E?
You could. 6E is a very powerful provision in the INA. And so, yes, it would, again, this is highly fact specific, but yes, that just because the 6C doesn't attach because someone cured doesn't mean that that would flow. There's no way, you don't actually have the ability to finally retract for the 6C.
Right.
The aid and abet thing, that's a one and done situation. Now, in the real world, are we going to spend a lot of time on that? Probably not. We have a lot of people, and again, talking about my posts, I can't talk about other posts. We have a lot of people to get through. We don't have a lot of time to spend drilling down on people unless we think they are involved in something significant. If we think there's some type of fraud ring or that scenario, then we're going to spend more time on it. But that's not also going to be my unit. That's going to be fraud prevention unit. So.
Okay, thanks, Martin. We're going to go to Dan, but Bob, did you have any comment that you want to say just for later?
No, I can actually.
Okay, perfect. So Diane, you might.
All right, so we are going to talk about another recent change in the FAM, the 90-day rule, which is 9 FAM 302.9-4 B3G. Okay, so the 90-day rule relates to activities that occur after a person has been issued a visa and has then arrived in the United States and has undertaken activities inconsistent with the issuance of the visa. Our clients, not infrequently I would have to say, ask us, how will they know? So, putting this in context, let's take a look at one brief scenario. A person who comes to the United States to go to Disneyland and ends up taking unauthorized employment. First, how do you know, and how does that play out under the 90-day rule? Martin?
Okay, thank you. Okay, so let me make sure I understand the question. Who is the person that doesn't know, or who am I sort of responding to doesn't know? Is it me, the consular officer?
How do you find that?
How do I find that? Oh,
Yes.
okay, it's 2018. We do. We're now omnipotent. Computers, TV screens, we know everything. It's all there. In fact, we're getting right now as we sit here. It comes. How is it going to come up? We're going to see it probably in the context of either a family number, most likely. It's going to come up in a family member's visa application, or someone is going to come back to us. Now they did this. They got your work that you were talking about, and they now need to either come back to see someone in the Philippines, or they're trying now to do it the right way. And we find out, oh, what have you been doing for the last 6 months? Oh, well, I've been working at whatever, widget X company. So that's how we're going to find out. It's either going to be in the context of another family member applying, or they're going to come back themselves. That's how we do it.
Okay, so now let's talk about love. David, we're going to pull you into this question. And this is, what does it matter? So, for example, someone gets a visitor visa to come to the United States to visit a boyfriend. And while they are here, within 90 days, they marry. However, the U.S. citizen boyfriend files the I-130, indicating that the person will return to the post for consular processing, which does occur. Does that matter? Does that invoke the 90-day rule, David?
Okay. Let me say at the front, that never happens, right? If they get petitioned for in the United States, they're staying there. But just to accept the premise for a second, if they're in B2 status, they're allowed to get married, right? And generally speaking, if we had a relationship that we thought was valid. I don't think most of us would spend too much time trying to build a case for 6C1 at that hypothetical point. But honestly, I mean, the reason most of our couples get engaged or married in the United States is so that they can stay in the United States, not so they can come back to Vietnam.
Okay, so in a different context, the same thing occurs. The person gets a visitor visa, comes to the United States, gets married, and then does an adjustment of status. But at the interview, they explain that the circumstances changed. They hadn't really decided at the time that they applied for the visa that they were in fact going to marry in the United States. Again, how would you find out about that? And would you contact USCIS to say, this visa applicant lied to me during the application process? Please bear this in mind during the adjustment of status. Let's take that one. Russell?
Sure, no, is the short answer. I don't think so in terms of, there would have to be something else going on with the case that would require us to go into that level of depth on something like that. But, there is the concept of dual intent, right? That is sort of what David was alluding to. That you can change your mind. The law does contemplate for that. And so it would have to be really something that, for us to go after somebody like that, please keep in mind that we've got a lot of people to deal with, and we've got and again, as Martin said, I will just reiterate, this is not the U.S. government's position on anything. This is Russell Brown's position. There's big fraud and little fraud, as I used to call it, right? So there's stuff that really, really matters, and then there's stuff that doesn't. I mean, it's, yes, they got away with something. Yes, they pull the wool over our eyes. Does it really matter for the intention? Does what they did matter in terms of the safety and security of the United States, keeping our borders safe? And does it really matter in terms of violation of the law? Yes, no, somewhere in between. So.
I will just say that USCIS, the Seattle USCIS director anyway, has said that the 90-day rule makes no difference to them in terms of adjustment of status processing. They say, we have no time frame. If you intended to get married when you got your visa application and you married 120 days after entry, you're going to take a look at that.
Let me just add on that. Something that David said is 100% right. You can marry in the United States. In fact, there's a little example in FAM on just this point. It is marry and intend to settle in the United States. That's not something that you just suddenly change your mind on a whim. Presumably because you've already overcome 214B, which showed us, demonstrated to us, that you have such ties, whatever those may be, that will compel your departure from the United States after a temporary period of time. So you already demonstrated. You've already demonstrated that. It's that second part of it, which is intending to settle in the United States, that you don't do on a whim.
All right, thanks. I just want to ask this, I'm going to cut off some of my time on the next one, just to follow up a little bit. So, at your post, Dave and Martin and Russell and even Bob, do you typically, do you have a lot of people requesting visas to marry in the U.S. on a visa that are going to return? Do you see that much on your posts? And do you deny those if you get them, or they typically approve? Go ahead. Dave, start, then Martin, and Russell, and Mike.
No, never.
Never.
Yeah, I can honestly say that I've never had that. We have people that want to give birth in the United States that'll be upfront about it, but I've never had an NIV application to go get married.
We do actually have this. In fact, I have a case in front of me now. There's two people, both want to go to the United States. They have visas before they both want to go to the United States, get out and then go back. But those both Filipino. We do see cases where there's an American in the United States and the Filipino wants to go and get married, but says that they have no intention of staying there. It's real rare, but we do have that. And do they get to go? Do we give them visa? Well, it's fact specific. They can demonstrate to us that they've got such a situation that makes it likely that they're going to come back. They have convinced us they're going to come back. Sure.
I screwed up my hypo. I should have said where it's an expat American citizen, where they're going to return. And that we do see. I know sometimes it's hard for consulars to make the jump to Cambodia. They ultimately did. But
Sure, but remember that at least with our post, there is an enormous American expat community that is permanently based there. There's more than 350,000 Americans in Philippines permanently based there. That doesn't count the extra many hundreds of thousands of Americans who visit annually. So the possibility of there being truth to the fact that somebody wants to go get married in Guam, sure, to an American. It's going to be tough, though, for them to establish, or maybe not so tough, depending on what we know about their case, that they are based in the Philippines and they have no intention of staying in the United States in adjusted status.
Yeah, and I'm just saying in Hong Kong, going back to what I said at the beginning of the session, Hong Kong is a low-fraud post. We have a really good applicant pool, especially if you're talking about those Hong Kong SAR, or British National Overseas Passports. It's not at all unusual for Hong Kong residents to get married in the United States to American expats. We sort of people who we generally refuse visas to people simply because they're going to be married in the U.S. concerned that they violate the terms of their lives.
So dual intent, present intent to visit. That's what you may have a future intent to immigrate, but if they're eligible for V. So I'm going to jump into the spousal case. Dave, you're going to be up first in terms of meeting the relationship burden. I'm going to give you a compound, Dave, to tie the first three questions together. Are all consular returns for fiancés and spousal petitions returned to USCIS based on fraud or misrepresentation? That for cases that were returned for less than fraud, okay, so for example, due to not enough evidence for a continuing relationship. How do you apply this in light of an approved petition being prima facie evidence of ineligibility for a visa? And finally, what are some examples of ineligibilities less than fraud and misrepresentation?
Okay.
That have to do with relationships.
All right. First off, no, not every petition that we return is because of fraud or misrepresentation. We do have a lot of petitioner deaths or withdrawals that they go back, but of the remainder, almost all of them are returned on the basis of evidence that the relationship is a sham. Second part of your question was, oh, right, okay. I want to record for the record my strenuous objection to the term less than fraud used to describe relationship fraud. In Saigon, we call it fraud, and it's about 95% of what we spend our time investigating. And in terms of, your question was what, how do we send this back in light of the petition approval being prima facie evidence, etc. Prima facie, as you know, does not mean irrefutable. So when we do return a petition, it's based on evidence that we've developed in the course of a fraud investigation that the relationship is a sham. Examples. How much time have I got?
Yeah, well, not that. Just three.
Okay, sure. I think probably all the consular officers on the panel could spend the rest of the time you have telling you stories of what we found in fraud investigations. But to make it as brief as possible, fraud investigations in Ho Chi Minh City are either a parallel interview, either in person or by phone, or what we call a site visit, where we actually go out to the beneficiary's residence and talk to them and look around. We spend a lot of time looking at people's phones, at chat records and the photos they've got saved there.
Can I interrupt? How are you looking at their phone? Is it you grabbing it from security outside, or?
So usually what we do is when we go into the house and talk to the beneficiary, we say, would you mind showing us your phone? And the beneficiary does that. So I get very high rate of cooperation here. So I think you can imagine the types of things we find, like in chat records, in the cases that we do send back, we'll see very detailed accounts of payments that a family member made on behalf of the beneficiary to the petitioner to induce him to file a petition. I remember one case where the beneficiary's phone had a chat with her boyfriend where she was saying, yeah, the relationship with this guy, it's a complete sham. My family paid him $40,000 so that I could go work in the United States and send money back. And then I think the best information is from the actual visits to the beneficiary's house. And I'll give you just a couple of examples. In one case, we had a CR1, and when we arrived at the house, the beneficiary was having this really loud argument with her sister. Sister was really angry, so she came up to the investigation team and just said, yeah, the relationship with the petitioner is a complete sham. He's actually the boyfriend of another sister of ours who's living in the United States. And then she gave us pictures to prove it. In another case, this is one of my favorites. We were visiting a house in a village out in the countryside. It took a while to get to the place. And when the team got there, they saw a big crowd of people gathered who were dressed up for a party. And there were some banners placed around the area. And they saw the beneficiary's name on one of these banners. And then there was another name too, it was a male, of someone other than the petitioner. So somehow they had stumbled into the wedding ceremony between the beneficiary and somebody other than the petitioner. And when you do as many investigations as we do, I guess the law of averages says you're going to do that eventually. But that was a fun one. So look,
Hey, you're not going to get everybody's stories, I guess, but I can see. Would you guys like to see a panel sometime where we just talk story about? Would that be good? 2 hours. Can you do that next time?
look, one final point. I'm sorry. I picked some of the most blatant examples, but I do want to say that these were not very hard to come up with. One day last week, I sent an email to my guys just before lunch, asking them for a few stories. By the time I got back to my desk, I had enough material for probably an hour or 90 minutes. And I took a really short lunch.
I'll interject just as a practitioner from dictionary. That's the first thing I do when I meet a new client when they get dynamic concert sections. I say, let me see your phone. I look at it right away because I want to know that I'm dealing with the righteous person. So it's an easy cut to the chase. We also do relationship checks on them. I've got them, I split them and do them, and I'm going to find out what the relationship on them. So, but would you guys like to comment with that? Did David sum you up pretty well? Let me throw this down in. As consular officers, we know there's this debate about bringing USCIS to this final day just to communicate petitions and get the thoughts out of the picture. Do you see yourself as reviewing or adjudicating petitions? Do you think that the consular officers are better situated to validate the beneficiaries in person? I mean, which is the whole point of the interview. How do you, if you're allowed to answer that, how do you see that? Maybe Russell.
Well, you can tell from my reaction that no, I mean, we're not there to re-adjudicate anything, right? So we're there to adjudicate. If there's information that is available to us at post that was not available to the USCIS officer at the time of adjudicating that petition, we will bring that into the case and we will make the decision accordingly.
Do you, I'm going to either for Russell or for Dave, how do you approach negative factors when they were addressed on the original petition? So the attorney addresses the problems, explains that USCIS approves the petition knowing that, so that wouldn't be something you're going to learn at the interview unless you learn something more about it, right? So how do you look at that? And then where maybe post has denied sent the case back to USCIS and they reaffirmed it, then how do you look at that? Whoever feels most comfortable. Russell, you want to take it?
Well, sure. Dave, you're welcome to jump in too, but for NID, obviously, it always depends on the nature of the issue, and it depends on what information is available to us. For ID, no. Basically, that we don't, in Manila, there's no point in going into that. So basically, the answer is no. Dave?
Sure. I'm sorry, I keep saying this. It doesn't come up so much for us because normally the meat of our revocation memos is this is a fake relationship, and that's not going to be a factor that USCIS already considered when they approved the petition, right?
Right. So when they reaffirm and it comes back, are you going to cover those same issues?
No. I mean, if we look at it again and decide there's still a problem with the case, then in order to return it a second time, we would have to have different evidence to support the revocation memo. I personally don't want to push adjudications in that direction. Normally it takes, I don't know if you, well, I'm sure you know this, it takes anywhere between 8 months and 2 years for a reaffirmed petition to come back to us. So if we're looking at that and think we got it wrong, then we try to get it issued as quickly as possible. If we still see problems with the case, we're definitely going to think hard about it before we push it back to FBU.
Thank you. Bob, you're going to go in, Diane. Bob, do you have anything in that, or you want to reserve for the other? Okay.
And then for coastal revocations in the NIV context, where you have, let's say, an 01 and the beneficiary appears before you for the interview and you decide, oh, you're not that extraordinary, you're not that exceptional, sending the petition back. Those types of cases can take, as Dave pointed out, maybe 2 years to wind their way through the process. We understand they first go back to KCC, Kentucky Consular Center, and then back to USCIS, and the petitioner may decide just to withdraw and refile. So is there any, let's say, prejudice when an NIV case that you have returned to USCIS returns back to you?
I guess there's 2 ways of answering this. The first is we would look at someone and judge their extraordinary ability, to put it in the language of the family, on the basis of what they tell us. And if they tell us something that's not in the old petition, we're going to send it back. If, however, it has now been re-looked at by USCIS and it's come back to us, we're done. We're not going to waste our time playing a circular game. If, however, they have decided not to respond and they refile, I guess, another O, and that's been adjudicated, and then comes to us, we're going to look at them again and say, okay, so you weren't an extraordinarily ditch digger, now you're an extraordinary plus point. Okay, we'll look at that, and whatever the criteria are for that, and how you meet that goal. We're not going to say, well, just because you sort of were really great at X job, that means you're probably not really great at Y job. We don't do that. Every application has to stand on its own merits.
Okay, and just, we've gotten a lot of really good questions here. Many of them are fairly detailed. We won't have a chance to get into them, but there is one sort of theme that I think weaves into our summing up here, and that's whether, other than publicly announced measures like BAM or changes in the State Department, whether you feel that there is any pressure to tighten up the standards or deny these applications, more so under this administration than previously.
No.
Yeah, that's true. You know, despite what you see in the press and that kind of thing, there's a question here. For instance, has our new Assistant Secretary for Consular Affairs directed us to do things differently in terms of fraud, or is the tone different? Are we tightening up more than ever we were before, or something like that? No, the answer is no. We're as tight as we ever were, and we're going to continue to do our work in exactly the way that we've done it before. Now, in terms of, there is, you know, country-specific type stuff that you guys are all aware of, that's making its way, you know, to, you know, in front of the Supreme Court and that kind of thing. But the countries that you're dealing with aren't necessarily directly affected by that. So we just don't see any impact of that on our processing.
So are we into the next section? Okay, just want to be sorry. Overcoming provisional 6C findings before constant return. So in some of the posts that you guys work at, there'll be a denial on a spousal visa typically, or K, and are we able to go back in and what's the procedure? I mean, typically it's before you send it back, right? Isn't that the deal? Dave or Russell on IVs? Dave, you want to take that first?
Sure. Okay, so I think the question is basically, well, let me do it a different way. When we send a case back to USCIS, it's gone through an interview. The applicant has been told to bring in more evidence usually to support the relationship. It will have gone to our fraud unit and stayed an unfortunately long amount of time. And to answer your question, I think you're asking, can you hit that window from after it comes back from FPU and before we send it back to USCIS? That's a really small window. And this happens to be one of our administrative days today. My guys are downstairs right now writing memos to get those things out of the door as soon as possible. So the honest answer to your question is no, you really can't do that. And the other part of the answer is you've had plenty of chances already at that point. I don't know why anybody would wait to that stage to try to get information to us to help us not return a case.
Yeah, typically we'll be getting it. If it was in our case and the person is denied, then they're pro se or they have some bad advice and they come to us. And so to avoid that 1 year or more timetable, we'll want to jump in ahead of time. We have different posts. Typically, we've met with city before. We've been told it's about a week to 2 weeks, and it's some very difficult once a month. Is that fair? Okay.
That sounds very inefficient to me. We might have made some improvements since then.
Ambitious, right? You said
Inefficient. So, yeah, in Manila, it's around 2 weeks or so. There might be a bit of opportunity, but we're not, once the applicant has left the building, and it's in the process. Obviously, folks can try to get into this very, very narrow window, but is there going to be enough that's going to really make a difference in the case? That's the question.
Well, that would be like getting an injunction or something. You have to show it's likely to succeed. In my history, we've done tons and tons and tons, and they issued visas, so it hasn't been for naught. Right? If you can establish that as a practitioner, you're knocking on the door. This really matters, and it's likely. Okay. So, Bob, do you have anything on that in terms of interacting?
Well, I can speak generally about interacting with consular sections.
You know what? I want to get you on that right after this because I think we're up to the questions that we got. I don't know if we got any online questions. Do we have? We've got the ones from the room. If anybody's monitoring online, no questions. I'm talking to the online people. What? Wake up!
Just to answer that, just
You can start with that
question. Again, whether we're talking about fraud or any other reasons for sending a case on back to Washington or to another agency, because we don't have a lot of problematic cases, we don't sit on them. It might be 2 weeks, 10 days is a good rule of thumb some places. In the case of Hong Kong, we'll probably talk about 2 or 3 days.
So, Diane, do you want to take the questions? We got 5 minutes for that, and then 5. Do we have enough time because we had a late start? No.
2 minutes.
Okay. Draw the questions. Pick one.
Okay.
And then we'll get 5.
All right. Here's a question about an applicant who had a 10-year B1, B2 visa and described a purpose of the visit to go see the Statue of Liberty. They still got that 10-year visa. Now they want to go back to the United States to look at investing and opening an entity in the United States. Do they need to come back and check in with you to tell you that they now have a stated purpose?
Please, God, no. No, they're wasting their time, they're wasting our time, they're wasting everyone's time. No, they've got a 10-year visa. if they're going to go do something lawful, which is what they're going to do, go, have fun, lawful. Please don't bother us. We don't want to see you again.
Definitely the answer we want. Why don't we go ahead and have Bob then?
Yeah, let's go. And Bob, and I'm gonna ask these guys like overtime they do on shows. We can provide those questions to you if there's anything you feel like after, and we can publish them out. Okay. So I introduced Bob. You don't know he was a cop before. Then he was SWAT team. Then he was a state prosecutor. So he was late in life entry to service, and he wanted to impart. He's got about a year left. To have a year left, and he wanted to impart his wisdom to us. We thought that would be nice.
Wisdom. Yes, I am a trained killer. So be careful. When I wanted to talk to all of you about, I wanted to take this opportunity to talk to you. And as Wayne said, I've been in the Foreign Service for a while now, more than 2 decades. I'm facing retirement. I mentioned before I spent some time in the visa office, and I just wanted to talk a little bit to all of you about how to approach consular sections when you have issues with them. And this goes beyond 61, it could be anything else. This is what I'm about to say. I'm sure it won't apply to any of you in this room, but I would ask you to please share it with the other members of AILA as you talk to them. This is the standard: you catch more flies with honey than with vinegar. And I hope you understand what I'm talking about. Perhaps some of you in this room haven't gotten that message yet. Let me tell you who you're dealing with when you're dealing with consular officers. Most of the time, you are not dealing with attorneys. Yes, there are attorneys who have become consular officers, like Mark and like me, but Russell is not an attorney, although he's been a consular officer for a very long time, and he knows his stuff. He's youthful looking, but he's been around for a while. But keep in mind, you are not dealing with attorneys for the most part, which means they may not have as nuanced an understanding of the law as you do. And it's really, really important that when you deal with consular officers, and that includes consular section chiefs, it's important to provide a full picture of what's going on. Keep in mind that because most consular officers are not attorneys, many of them share the general attitude that the public has about lawyers. You know, that sad lawyer, liar kind of connotation. They won't always trust you, and so you have to try to work to build that trust. Keep in mind what it is they all do, especially in the NIV context, which is where a lot of problems arise. They get to talk to somebody for a couple of minutes. They size them up, make a decision, and they move on. As I said earlier, limited amount of time. We don't have a lot of time. You got to make a decision and go. Keep in mind what their role is. It is just that, to size somebody up and move on. If we deal with them, they are not opposing counsel. I used to be a prosecutor, as Wayne mentioned. I was used to dealing with opposing counsel and the sorts of back and forth, not always pleasant exchanges I would have with opposing counsel. You treat a consular officer like that, you're not going to get anywhere. Right? Consular officers are not opposing counsel, they're judges. And if you don't get that, you're in the wrong business. Okay? And when you're dealing with the consular section chief, you're dealing with the appellate court. And just like in any court system in the United States, the appellate judges know the trial court judges. And so if you're insulting the trial court judges, the subordinates of that consular officer is probably not going to be very happy about that either. The attitude that you project, the way you approach people, will have an effect on the decision. You may be right on the law, you may be right on all of the merits, but if you approach it the wrong way, you're not going to get any consular officers. They're just regular people trying to do their job under time pressure. It's really, really important to keep that in mind. So my message to you is, when you approach consular officers, do it respectfully. Help them reach the right answer. And please don't ask them to do something they can't do. The standard of review that a consular chief will use when looking at a consular inquiry, consular decision. First of all, did my subordinate misapply the law? And I'm here to tell you that 99 times out of 100, the subordinate didn't misapply the law. It happens sometimes with regard to INA 212A eligibilities, but a lot of the inputs for debt have to do with the NID side. Again, with 214B, and that is a discretionary decision. And when it comes to discretion, it's just like an appellate court in the U.S. If the lower court, if my subordinate did not abuse his or her discretion, I will uphold that decision, even though I might have made a different decision at the time. I'm not going to re-adjudicate the case at the appellate level any more than the appellate court in the United States would adjudicate a court case. I'm not the fact finder. The facts have already been found. But there's a problem with the facts supplement. And again, try to help the consular chief and his or her crew reach the right decision. Be a helpful participant in the process. Don't come on like gangbusters. It's not going to get you anywhere. When you lose at the post level, then you go to legal net. And they're all lawyers. You can do whatever you want with them because they get it. But when you're dealing with consular folks, approach them in a collegial, respectful, and honest manner. Remember, dishonesty and confusion never benefit the clients. So, straightforward. I say anything you guys disagree with?
And with that, we're finishing our panel. I want to thank Martin and Russell. They flew in the farthest. And from Manila, they've been great partners. We've had conferences there. They've always participated. I want to thank Bob for hosting us here in Hong Kong and being here with your fellow colleagues for another panel. And Dave, who televised in from Ho Chi Minh, also very great. They participated a lot with BDC through the years. And thank you all for coming. And sorry we went over just a touch.
The next panel we get in about 10 to 15 minutes. 10 minutes.